XRP is entering a new level of development. How much money do you think this will bring to investors? Write answers in the comments. Social media has become a battleground in the ongoing legal battle between Ripple and the U.S. Securities and Exchange Commission, SEC, with some users arguing that the latest court verdict will have little to no impact on the cryptocurrency industry, while others are vehemently to the contrary. An ex-SEC attorney, John Reed Stark, called the recent rejection of the agency's move for an interlocutory appeal by Judge Annalisa Torres a Pyrrhic victory at best for the XRP team in an X post published on October 6. After the trial, the governing body will still undoubtedly appeal the decision, and I believe have a good chance of winning, Stark says, since the judge has specifically deemed her decision as not precedent for the rest of the cryptoverse. Moreover, he disregarded the most recent judgment by Judge Torres as precedent on the issue of whether tokens are securities, saying the court did not hold that offers and sales on a digital asset exchange cannot create a reasonable expectation of profits based on the efforts of others. The former attorney for the SEC specifically stated that the court held that based on the totality of the circumstances in this case, including an examination of the facts, circumstances, and economic realities of the transactions, Ripple's programmatic sales could not lead investors to reasonably expect profits from Ripple's efforts. Emphasis in original. Agreed to disagree on the legal impact of Judge Torres' rulings, but you also seem to be saying that XRP uniquely stands as the only digital asset, other than BCC, with judicial clarity as a non-security. Stuart Alderodi, the chief legal officer of the blockchain company, responded to Stark's post. We're on the same page now. Attorney Jeremy Hogan simultaneously listed multiple potential outcomes for the Ripple v. SEC case after the judge denied an interlocutory appeal motion, including the regulator proceeding with a trial next April against the individual defendants and an appeal of the case no sooner than 2025, with an appellate ruling no earlier than 2026. Alternatively, the SEC may settle all litigation against Ripple and the individual defendants at a settlement conference on April 16, 2024, or it may proceed with obtaining a final judgment against Ripple and then appeal. On 6 October 2023, John Reed Stark, a regulatory compliance specialist in the digital arena with a 15-year stint as an SEC enforcement attorney, turned to social media platform X, previously known as Twitter, to offer his thoughts on Judge Torres' recent ruling involving the SEC and XRP's recent ruling involving the SEC and XRP. Stark underlined that the judge's decision to deny the section interlocutory appeal also said that her earlier summary judgment should not be treated as creating a legal precedent unless the circumstances of a new case are similar. Stark pointed out that although this may seem to be a little success for the XRP team, it might ultimately be a hollow victory. He expects that the SEC will appeal the verdict after the trial and will have a decent chance of prevailing. Judge Torres has specifically said that her ruling is not to be regarded a precedent for subsequent lawsuits in the Bitcoin industry, according to Stark. Stark also praised John Deaton and the XRP team for opposing the SEC's unilateral law-making techniques. He stated his displeasure with attorneys who switch between law firms and the SEC, implying that such lawyers are unlikely to question the existing quo owing to possible conflicts of interest. Stark applauded Deaton's team for spotlighting the SEC's unappreciated efforts in fighting less publicized but critical issues like microcap fraud and penny stock fraud. However, Stark was emphatic in declaring that Judge Torres' ruling on Ripple should not be regarded as a precedent on whether coins are securities. He emphasized the judge's unequivocal statement that her judgments were based on the Ripple case's unique facts and circumstances. Judge Torres rejected the SEC's assertion that the issues posed in the case are crucial legal issues with far-reaching repercussions for several other cases in her judgment, denying the SEC's motion for interlocutory appeal. She stressed that her judgments are based on applying the Howey test to the particular facts and circumstances of this Ripple instance. Judge Torres went on to remark that the SEC's references to previous enforcement proceedings involving various digital assets and firms are not directly comparable owing to differences in facts and economic circumstances. She also corrected the SEC's interpretation of her findings, indicating that her order should not be seen as creating a precedent for subsequent digital asset matters. The SEC had specifically tried to determine whether an issuer's activity on cryptocurrency trading platforms may establish a reasonable expectation of gains for investors. Judge Torres noted that her decision was not a blanket pronouncement on the subject, but was based on the whole set of facts and economic realities of Ripple's programmatic sales. The current triumph is surely a last nail in the coffin. The issue is whether the SEC will abandon the complaint or negotiate a settlement with Ripple. The court's decision to deny the SEC's appeal confirms an earlier judgment that secondary XRP sales do not fit within the category of securities transactions. This demonstrates that Ripple's activities in selling XRP tokens do not violate securities legislation. Judge Analisa Torres' judgment dealt a blow to the SEC's legal approach and exposed several significant flaws in its claims. The SEC's approach was predicated on the argument that some XRP sales might cause investors to expect rewards based on Ripple's initiatives. However, the court deemed this argument to be devoid of significant evidence, confirming the prior ruling. Ripple's CEO, Brad Garlinghouse, didn't pass up the chance to remark on this recent event in his ex-post after Deaton. He humorously observed that the SEC, in its pursuit of applying the Howey test in the case, ended up on the losing side. He mocks the SEC's own creation of this test, on which they were slammed in court. They seem to want the services of an expert lawyer to comprehend the significance of their own made-up securities legislation. Looking forward, the SEC now finds itself in a situation where it must await additional findings in the overall litigation against Ripple before considering any appeals. The next central hearing is scheduled for April 23, 2024, with both parties needing to file pre-trial materials by December 4, 2023. According to Jeremy Hogan, the matter will either go to trial in April or be dropped. Furthermore, this judgment enhances the judge's prior ruling, making it more difficult for the SEC to win in any prospective appeal. As the current tide is moving towards Ripple and Coinbase, the SEC may be in a stronger position if they act in their best interest to introduce clear crypto legislation. The SEC is at a crossroads. In a recent disclosure, digital asset researcher Anders revealed why the U.S. Securities and Exchange Commission, SEC, chose to go after Ripple and its XRP. The SEC's allegations against Ripple in December 2020, citing the sale of XRP as an unregistered securities offering, sparked discussion in the crypto world, especially among XRP fans. In his thread, Deaton offered a range of thought, provoking questions about the SEC's special targeting of XRP. He questioned why the SEC would choose a more difficult case, drawing parallels to the early sales of ETH when the Ethereum team launched a simple initial coin offering ETH. Anders points out that the SEC's determination to target XRP arises from Ripple's creative usage of the digital currency in cross-border settlements. According to Anders, Ripple's use of XRP undermines the conventional nostro-vostro accounts and banking paradigm, which has long been a substantial income source for many big banks. According to the researcher, this disruption has the potential to expose established financial institutions' lack of innovation. It is critical to note that Ripple Labs is mainly focused on transforming blockchain payments, with XRP playing a critical role. Ripple removes middlemen in cross-border settlements, which reduces delays and expensive transaction fees. Notably, ODL uses XRP as a bridge currency to provide smooth conversion between multiple fiat currencies. Following a federal court judgment, Ripple continues to stress XRP's non-security categorization, cementing its status as a valued asset in the cryptocurrency ecosystem.